Jane Brown, probate, wills, and estate attorney here at Gunster. What a subject that you have to cover. Good heavens, it goes on forever and ever, does it not?
Oh, absolutely.
Particularly to our Palm Beach audience.
Yes, yes.
And it seems as though, death and dying is part of everyone's life, but when it comes to death and dying, nobody really wants to speak about it. Can you tell me a little bit about some of the challenges you have with that subject?
Well, most of the clients that we have when they come into our office, they're well prepared to discuss it. They've had to think about it themselves, and perhaps the struggle they have, they've had independently. So when they come to meet with us, we have a number of questions that we have for them. Generally, we plan for, or we ask them questions about what they're going to do if they become incapacitated first, and then what their wishes are upon their death.
Will you have a husband and wife, or will the whole family come in? How is this handled, or can it be handled in any number of ways?
There are a number of ways that you can address it. First of all, we might represent just one client in a marriage, or we might have a joint representation where we represent both the husband and the wife together.
Are there any conflicts there, or does that depend upon their marriage or their number of marriages, or how is that a smooth transition to have both of them?
Oh, certainly. I mean, you make a really good point, because if there have been multiple marriages and this is a new spouse and there are children from another marriage, then typically we would only represent one individual, and what we would discuss with them would be confidential. We wouldn't involve the spouse in any of the decision making.
And the decisions that they make, can they be changed?
Oh, absolutely, yes.
Anytime? Should they be revisited every year? If you've put a trust together, what's the important thing to remember about that, depending on the type of trust?
Well, if it's a revocable trust, then certainly they can change it as often as they like. If it's an irrevocable trust, well, then that takes a lot more careful thought. And those types of trusts, they're just like the word said, they're irrevocable. You can't change them. So a lot of careful thought and planning needs to go into the terms and the content of those types of trust arrangements.
Does that mean ever?
Ever, that's right.
So once that's put in place, no matter what happens going forward.
That's absolutely true, except for the fact that you can put provisions in there that would allow another person to alter the dispositive plan under certain circumstances. But if you establish the trust yourself, and it's an irrevocable trust, you aren't able to change it again.
Okay, we've talked about the one D word, the death word. Let's talk about debts.
Okay.
Ending your life with a mountain of debts. Can that be a problem? Is that not a problem? Or again, does it depend on how you've pre-thought everything?
Well, it really depends on how many assets you have to offset the debts.
Okay.
And as long as there are sufficient assets, then the plan, as long as it takes into consideration those debts, the plan should work. But a careful analysis of what the existing debts are is going to be crucial.
Have you seen instances where something on the outside looks like it's very rosy and there are plenty of funds there, and then in reality it turns out to be more challenging?
Yes, certainly that can take place, and there's really two instances where we see that happen. One where there's a last illness, and the client establishes a plan, and then many years go by where they're unable to change it, and they spend a lot of their assets during their lifetime on their last illness, on their care. So the wealth that they may have had initially is diminished somewhat, and the plan might not work exactly as they originally intended.
I have heard stories where people will spend an awful lot of money putting a trust together, and then they won't fund it.
That's true. That's true. Often, many clients do that, but there are ways that they can be funded. For instance, if you have a pour-over will, the will direct that any assets that aren't already in the trust are distributed to the trustees and then administered pursuant to the terms of the trust. And then another way that they can be funded is in the event of your client's incapacity, a power of attorney can be used. The attorney, in fact, can transfer the assets from different accounts that are in the individual name into the name of the revocable trust.
Okay, and one last question. What are a couple of the most misunderstood items when it comes to this grand subject?
Oh, many clients believe that if they have a revocable trust, that they're also avoiding estate taxes, and that's really not the case. A revocable trust is very useful in avoiding a guardianship or in avoiding a probate administration, but it's not effective in avoiding estate taxes.
Any kind of estate taxes.
That's right.
And what about any other kinds of taxes that could you be faced with at the end of life?
Well, there are also income taxes that will be due on all of the assets.
And debts that need to be paid too, although there won't be taxes on that.
Right, that's right. Mm-hmm.
So it kind of comes down to really understanding what kind of trust you've put together and the ins and outs of it.
Yes, certainly. And it's not just the type of trust, it's going to also depend a lot on the terms, the contents of those trusts.
Which can be changed.
If it's
Provided.
a revocable trust, yes. Mm-hmm.
Okay. Anything that you would like to say that never gets said enough?
Oh, if the primary message that I'd like to get across is that it's really important to have a plan. You can always fine-tune the plan, but you need to start by having a plan. It's the clients that don't have a plan at all that are they're in the worst position.
Thank you.
You're welcome. Thanks, Diane.